Well, good morning to you all. We're going now to turn to discussion about dispute boards. Somebody coming from a non-dispute resolution world might be astonished to hear the levels of sophistication that there have been in the speakers so far, and I can tell you there's going to be equal, if not greater, level of sophistication among the panelists, not me. But it's been quite striking how specialist the conversation has been. Before we start off with a discussion about, do you have one adjudicator, do you have three, then do you go first with adjudication, is it part of a process, is it not? And what are the differences between adjudication in the UK and adjudication in other areas? Well, now we're going to add more layers of complexity to this, because we're going to discuss dispute boards, but we're going to discuss dispute boards from the perspective of a number of different jurisdictions. And we will be also hoping that now you've all had a cup of coffee, you will all be awake and therefore willing to receive a roving microphone and give us the benefit of experience from the audience as to what you've experienced with dispute boards, pro and against. But we're going to start with some minor interruption of that process, but with some, each of the panel is going to say a few words about their experience in very different jurisdictions. I'm going to start with Kailash Dabeesingh, who is coming from Mauritius. He's had an extraordinary career, engineer, then quantity surveyor, then barrister, first of all starting in this country and working in industry, and then moving back to Mauritius, where he acts as a dispute adjudication board member, and he's actively promoted, I think you'll gather, promoting ADR in Mauritius, and he's the current president of the SCL Mauritius branch. And he's going to tell you about what are really quite exciting developments about dispute boards in Mauritius. Thank you very much, Kailash.
Thank you for this nice introduction, Chairman. Ladies and gentlemen, good morning. Yeah, indeed, I come from Mauritius, and this morning I'm going to talk to you about the way we do dispute adjudication board in Mauritius to resolve disputes. Just to put everything in context, now, Mauritius is one of the most competitive and successful economies in the region. It is recognized for its stable and democratic government, well-diversified and dynamic economy, fairly well-educated population, and a strong legal environment. Now, as in all emerging economies in recent years, all aspects of construction processes have become increasingly complex, technically, legally, financially, in its speed and in size. So it's no wonder disputes have become a natural part of any commercial transaction. So they are part of the activity of commerce itself. So how did the construction industry in Mauritius operate? So the construction industry community in Mauritius recognizes that it is beneficial to acknowledge the existence of potential disputes and conflicts from the very beginning of any contractual relationships. It's a bit like crime in a society. We realize that we cannot prevent crime, but we can deal with crime in a very effective and in a very, very effective manner. And this vision has, to a large extent, been very illuminating and indeed very inspiring. So what the business community, the business construction community was looking for, it was a way to reduce the frequency of disputes, to make their settlement less contentious, and to shorten the dispute settlement period. Not only as a matter to reduce the cost, but also to increase the confidence of the investors. An important feature that we did not neglect or ignore, we realized that no dispute resolution method can deliver in equal measure a just, a quick and cheap outcome, because almost certainly it will be an illusion to look for one. So what we realized that the best method of resolution of any construction dispute is arguably the avoidance of the dispute altogether. So the construction industry has been very fast to recognize and emphasize the important role of dispute adjudication board before any dispute can arise in an endeavor to avoid disputes altogether. Now, although we embrace that concept of dispute adjudication board, there are two important issues that I would like to highlight. First of all, contrary views were strongly held for the proposed adoption of dispute board in Mauritius. The opponents of dispute board raised the fears that its adoption will just represent an additional layer of cost. The die-hard conservatives felt that a fine-tuning of the contract would suffice. And others argue that dispute board would undermine the powers of the engineer and should be dropped altogether. And the second issue was we had a technical and a cultural one. A technical issue, where do we get the dispute adjudication board members if at all we adopt the dispute board concept? But the turning point has been a series of systematic failures of our public contract. Our contract was marred in never-ending complaints of spiraling cost and ever-ending delays. So dispute board, in the context of dispute resolution, is a relatively recent concept in Mauritius. They are essentially a creature of contract, and the FIDIC conditions of contract is widely used in the country, and it makes room for the appointment of a dispute board at the commencement of any project. But before I go any further, I talk very briefly about the legal framework under which the contract operates. Now, in Mauritius, we have a legal system which is a hybrid one. It's a hybrid legal system which draws its inspiration from France and England. It combines both the civil and the common law practices. And that duality of concept which characterize the law is deeply rooted in the very history of the island. We were a French colony until 1810, when the British took over, obviously by force. So what I want to say, the French code of the civil procedure coexists with the English civil procedure rules. And over the years, as far as the substantive law is concerned, the British introduced a number of Anglo-Saxon concepts. So there is a predominantly Anglo-Saxon legal culture. No, until very recently, when it comes to war in the construction industry, the choice of the two principal battlefields in Mauritius lies starkly between litigation and arbitration. Over the generation, a particular culture has grown in Mauritius, with parties resorting at an early stage, almost as a matter of course, to lawyers. So what has happened? A single professional group has come to secure a virtual monopoly of control over dispute processes, but through no fault of their own. I think most of you will agree, lawyers generally approach disputes in a distinctive way, with only one approach to business disputes, the path towards the court at an early stage. Now, it is a matter of legitimate pride that we have an independent judiciary to resolve disputes. But for the litigants, going to the court has something of a toss of a coin about it. All that is certain, that it is unsettling and an expensive procedure best to be avoided. And when it comes to the other battlefield, which is arbitration, it was not regarded as a recognized field of practice. Until a decade ago, it played a very limited role for the resolution of disputes. And the very limited use of arbitration was not only a technical issue, but also a cultural issue. But all this has changed over the last 10 years, and arbitration has become a specialized field of practice. But, there is a big but, efficiency, cost, and expedition, which are generally regarded as a significant benefit of arbitration, are seldom being achieved. So the often touted objective of arbitration are not achieved. And although the outlook and working method of arbitration and litigation are different, they were considered entirely as the two sides of the same coin. So the increasing dissatisfaction with arbitration and litigation has given rise to a movement away from the classical form of dispute resolution. That is a movement away from the judge in the court, and a movement away from the arbitrator in his chambers. So the disenchantment with arbitration and litigation is the main reason for the emergence of Dispute Adjudication Board in Mauritius. And at the very heart and central to this mechanism is the demand in management specialists, in dispute management specialists, rather than dispute resolution experts. Now, there is a distinction which I would like to make between the dispute management specialist and the dispute resolution expert. By dispute management, I mean two things. It encourages the parties to engage in discussion. It means effectively, it means dispute avoidance. And secondly, it means that where the parties cannot avoid falling into disputes, they will enter into a structured process involving a third party for the formal decision. So Dispute Adjudication Board work in Mauritius. And a very good example of this was the construction of a recent hospital, where I happened to be the Dispute Adjudication Board member, and I was the sole member. And the value of the project was about 40 million USD, but in the Mauritian context, it represents a huge sum. So on that particular project, the DAB, the Dispute Adjudication Board, was rated as a substantial success. So in the course of the process, the role of the parties, their advisors, and the dispute board member, they were very cooperative rather than purely confrontational. So the DAB was able to issue advisory opinion rapidly, which allowed the project to continue with very little disruption as possible. And the provision of informal assistance before any dispute arises were of immense assistance. The other project where the dispute board had substantial success was the construction of the international airport recently. Now, obviously, on a project of this magnitude, it was a fertile ground for dispute to arise, but the Dispute Adjudication Board was perceived on that particular project as an organ of the project itself. The structure put in place was able to sniff out the potential conflict before they developed. And the dispute board was only required to issue advisory opinion. What we observed that one of the biggest advantage of the procedure was that it had real-time value. And by real-time dispute resolution, I mean that there was a mechanism that was put in place that could prevent disputes during the currency of the project. And the parties to the conflict were able to take full advantage of the knowledge of the project team and the team members in achieving a resolution of the contentious issues as they arose under the contract. The third and last project where we had dispute adjudication board was the construction of a new security prison. And the low number of dispute board decisions for a project of this scale and complexity provides a convincing endorsement of the effectiveness of dispute board in avoiding disputes in the country. So it is clear that the use of dispute adjudication board in Mauritius is not simply another ADR device. It represents the emergence of a structural change aimed at the prevention of disputes. And why I say there was a structural change, because the attitudes and the behavior of the parties who are involved in the resolution of disputes change significantly. So there is the creation of a wholly new attitude in the way parties perceive their disputes, the way in which they relate to one another, and the way they act in resolving the disputes. And experience also demonstrated that it encourages open discussion. So the early resolution of disputes greatly help maintaining a good working relationship. So to conclude, we realize that over the years, the construction industry dealt with the resolution of dispute for arbitration and litigation. Both processes have played and will continue to have an essential role, but in a very diminishing proportion. Neither arbitration nor litigation is truly innovative. And arbitration is no more a refinement applied to a system that has been used for hundreds of years. So as business becomes more sophisticated, the emphasis is on dispute management in contrast to the traditional dispute resolutions. So the dispute adjudication board model appears to be a worthwhile candidate for consideration. But there is one last point that I would like to make before I finish. So there is a big debate in the country which is raging. Where do we get the dispute adjudication board member? And how far and how fast we will run with the dispute adjudication board is another debate. Thank you.
Thank you, Kailash. Well, as I commented to Kailash earlier, there'll be a queue around the block to tell him where he can find the adjudicators. So please make an orderly queue. Next, we're going to have, I think we can count that as Mauritius puts a big tick in the box for dispute boards. Next, we're going to have Adrian Bell of the well-known law firm CMS McKenna, who has very extensive experience of DABs in South Africa. There may be a number of people here who are very grateful to the politicians in South Africa for creating quite a lot of chaos in the power station business. And I think Adrian has helped to bring some control to that, or not, through dispute boards.
Thanks, Roger. Good morning, everyone. At least I think it's still the morning. Roger asked us to come along and speak to you today to give a bit of background to our experience on dispute boards and then try and make some reflections on why they work or what we could do to make them work better. As he said, my experience with dispute boards is largely in Africa and the Middle East, and those of you that will have worked in the Middle East, historically at least, will say, well, why are we doing dispute boards in the Middle East? Because the first thing you do when you get a FIDIC contract is strike out the dispute board provision. But I think historically that's certainly been the case, although more recently I think there's a growing popularity of dispute boards in the Middle East, particularly because there are more longer-term relational contracts. PPP, for instance, is gaining popularity in the Middle East, and hopefully as a result of that we'll see further endorsement and further use of dispute boards in that region. What I'm going to do is try and promote to you a recipe for success of dispute boards, and I'll be very interested, if time allows, to hear people's reflections on why they agree or disagree with me. I think the best prospect of making a dispute board work is to have a standing board. People will appreciate the differences between ad hoc and standing boards. The standing boards are where the dispute board is in place from the outset of the contract. I think you need to have 3 people on the dispute board. I think they stand a greater chance of success than a sole dispute board member. And I think you need to make sure that you have a very carefully composed dispute board. We discussed this as a group when we were preparing for this session. I think the consensus was that you should have a legally qualified chair usually, but you should also make sure that you've got sufficient range of expertise. Probably the second or third member would it be a technical person and a quantum person. I can say you can have a legal chair because I don't sit as a dispute board member, so it's not turkeys voting for Christmas. I think you do need someone who has some familiarity with the local governing law of the contract and is familiar with the regulatory regime. So a standing board, 3 people, a good mix of people on the board. Obviously, one benefit of having the standing board is that they should have the familiarity. They need to be proactive. They need to be visiting the projects regularly, probably monthly. I think one benefit of that, or one maybe not so obvious benefit of that, is that when the dispute board process starts, it's usually a shorter process because you don't have the dispute board getting up to speed in the same way you would have with an ad hoc process. And having the standing board in place means that the dispute board is normally more inclined to get on with a quick process. And I think if you are going to have a successful dispute board process, it needs to be quick, it needs to be dynamic. Again, we were discussing this amongst us, and I think, most of the time when people say dispute boards haven't worked, it's when they've turned into a kind of quasi-arbitration process where it's been drawn out, it's taken many months, there's many rounds of submissions, cross-examination of experts, cross-examination of factual witnesses. So I think part of my recipe for success is to avoid that happening, to keep a fairly short-form, dynamic, quick-moving dispute board process. And I think, as I said, you need the right composition and you need a standing board to do that. I think you also need to make sure that you have the stakeholders in the project brought into that. You need the parties to fully embrace the dispute board process. It helps to be able to do that from the outset. The dispute board members have often quite a challenge on their hands to build the trust and the rapport with the parties, but I think it's essential that they do that from the outset and they maintain that. The site visits are often very helpful because it continues and enables them to develop that rapport as they go along in the anticipation often of a dispute arising at some point. And obviously you've got the other stakeholders, the funders, depending on how the project is procured. A lot of these other parties that are interested in project will have be very interested in the dispute board succeeding and will give authority and confidence to that dispute board. I think, how do we encourage dispute boards being used more often? How do we give them more teeth? I think if they're going to be successful, they need to have some teeth. They need to have proper authority on the project. Again, getting them involved from the outset, adopting them early on a project, making sure that they're part of the project team, they're integrated. As I said, the success of the dispute board will depend on the ability of the dispute board members to gain the trust of the parties and that rapport very early. And I think applying them to use their broad range of experience. If you've got a legal chair, a technical and quantum people in the mix as well, then make sure you're using the full range of the dispute board's experience. It's there for a reason and it should be optimized. And make sure that the dispute board, as I said, is making some very quick real-time decisions. The last thing, we've mentioned this, and I think many people in the room will hopefully agree that we do need the dispute board in the same way that adjudication does to be used during the currency of the project to unlock those issues and to prevent the parties becoming entrenched or bogged down in parties in particular issues. The other thing I was wondering is, can we give them more of a prominent role? Can we give them more authority? We see a lot of bond calls, and I think one quite interesting concept I've seen recently is, writing into the bonds that you can only use the bond, you can only call on the bond when you've got a dispute board decision. So again, that's another way to give the dispute board the authority that they need. Hopefully I've caught up a bit of time, because I'm really interested in hearing from people whether they sort of agree with that proposition that I've made about those recipes for success. And I think Scott's now going to talk about some various tactics and other things that you can use when you're involved in the dispute board process itself. Thank you.
Yes, next up is Scott Stiegler from Vinson and Elkins. Scott has had experience in the Middle East and in America on a rail infrastructure project, but I think most of his involvement with DABs has been in a big infrastructure in Central America, which can't be named, probably people will guess who it is. And so he has enormous experience of dispute boards in relation to vast infrastructure projects. So,
thank you, Roger. I suppose the first point I wanted to make is from your opening remark about sophistication of this board. I am Australian. I lack that inherently. So with that, as Roger has said, my experience is predominantly in larger infrastructure projects. What I have seen during my experiences, and these are my experiences alone, and I appreciate everyone has different experiences, is everything from disputes that have been resolved on the paper right through to mini arbitrations. And I get asked the question, and funnily enough, it's the question for this panel, why do dispute boards work? And should the question be, could they work or do they work? I'm taking two of Adrian's points just a little bit further, and I want to talk about what the parties agree the role of the DAB will be, and then looking at the parties themselves. So, looking at the role of the DAB, Adrian's put a persuasive case forward for a standing DAB, but whatever way the parties wish that to happen, we go back to the first principles that this is a creature of contract. And it's not only something that needs to be prescribed in the contract, but also needs to be educated to the DAB so they know what their role is. And there is sometimes a tendency for that role to be blurred, and their primary role is to adjudicate disputes. But when you have a DAB that sits for the life of the project, you get this natural tension between, are you a dispute resolver or are you a problem solver? And the two are not the same. So take the very typical example, the contractor is running out of time, running late, needs more money, but you hit a point in the project where by not awarding time or money now, because of cash flow issues, the project is in peril. A dispute resolver ought to deal with the dispute under the terms of the contract and the governing law, and to make a decision. That is its primary function. A problem solver may look beyond this and seek to find ways to render a decision that grants time and or money. That solves the problem, but does that resolve the dispute? Ultimately, 9 times out of 10, the parties end up in arbitration anyway, so you can see a DAB member thinking, I'm doing my bit for the project by passing cash through, it'll all be sorted out in the end. This is a natural tension and something I've seen a lot through my experience. When you look at the changes in the FIDIC forms as well, this sort of new emphasis on being more actively involved. Obviously, you could get an opinion on the 1999 form, but being more involved, being more in front of the parties, being able to raise questions with the parties and to say, guys, I think you should ask me for an opinion. Does that change the role of the DAB? Is that for the parties, is that the right thing to do? To discuss. The second point is, unsurprisingly, the parties themselves. I've never practiced in Mauritius, but it sounds like a wonderful place to be. Everyone gets on there. So again, my experience is what I typically see, you see either the sophisticated contractor who knows exactly what they're doing right from the very beginning and seeks to game the system. Right to the other end of that, you get the parties who have no experience at all, might not even know there's a DAB process in the contract, and at the very end, they end up in a dispute and realise they've got to go through this process and they've never done one before. We all love sharing war stories. We've been talking about getting the adjudications dropped on a Friday afternoon. I had one dropped on me when my son was coming home from the hospital for the first time when he was born, so bitter experience. Gaming the site visits is something I see a lot of. The DAB will come for its usual site visits, usually regularly, sometimes at key intervals. And this serves as an opportunity for the DAB not only to see the project, but for the parties to take advantage of that. And an experience I've seen is, unfortunately, quite a wonderful set piece where the DAB was taken around a project. This project was in the Middle East. And DAB was taken around, and there were ground conditions that were suddenly present at the site. And the contractor, in this case, was taking the DAB around saying, look at this, look at this, look at this, all these problems. Obviously, then the claim comes. DAB is prejudiced by that point. So that's one example. Again, I'd like to hear what other people have seen and what have done. That's certainly not a tactic that I would use personally, because guess what? DABs end up in arbitration 9 times out of 10, and the evidence is admissible. So do these guerrilla tactics work? I don't think so. That's certainly not how I would want to operate things. Again, circling back to Adrian's sort of key themes, why do they work or why could they work? It really depends on the parties and the framework you set in place. They have great benefit where you don't have an adjudication scheme. They have great benefit if you have a discrete dispute you might want to raise or deal with something on the papers. There's great advantage to that. Where I see it falls down slightly is where you have parties who are misbehaving, parties who don't know the process. They don't really engage in the process. Levelling up, which was a comment that was made this morning. Usually it's the parties, and one party might get an expert, another party might get an expert, we might have counsels, and guess what? You're in a mini arbitration. And typically, scale is always a big factor. The bigger the disputes they get, more likely lawyers get involved, more likely experts get involved, more likely the DAB process starts to grind to a halt. And unfortunately, while they do serve a very good initiative during the course of the project, typically we see them fail towards the end. Parties go, thanks guys, we've had enough. Let's go to arbitration and let's put the gloves on and let's go. Those are my experiences alone. I'd love to hear what everyone else has to say. Thank you.
Just before Iain comes forward, I don't want to get too gloomy about dispute boards. I had a lot of experience quite a long time ago when the new airport, what was then the new airport in Hong Kong, was being built, where the Hong Kong Airport Authority was immensely creative in what they did. They had a very proactive dispute board process, which did get rid of, 70, 80% of the disputes, the potential disputes, along the project. They then moved into start of arbitration. They then had very creative mediation of a sort which you don't see very often, which was sort of like a mini arbitration, but they would set aside 2 weeks, and they'd say, okay, quantity surveyors get together, engineers get together, lawyers, keep out of the place, you can come back in due course. And that settled, I think, every single one of the major Hong Kong airport disputes, except for one, I think, in the end. So it is a process which can work. But anyway, now from a different perspective, Iain Aitchison from Ankura is an architect qualified not just in the UK, but also in Germany. He's now an independent expert dealing with high-value ICC arbitrations, and also he's on the Chartered Institute of Arbitrators Dispute Board and has experience as expert and as a pointer and as a member, I think. Yeah.
So, hello everyone. What I want to talk about today is the experience that I had in South Africa on a major power project where I was working as one of 4 case managers managing the dispute board process essentially from the government side, so from the side of the power utility. On our desk at that time, there was something in the order of 40 referrals or potential referrals, and we were keeping an eye on the development of these. Now, we had a mixture of standing boards, ad hoc boards, and we had, more interestingly perhaps, a number of really quite bizarre mutations or hybrid forms, essentially where the standing board wasn't really standing but was waiting for something to happen, or the ad hoc board was so good or so busy that they were being called essentially to stay around for the next dispute. So there's quite a lot of chopping and changing going on. But the project was characterized essentially by an enormous backlog of contract administration. There was a lot of uncertainty, there was a lot of tension, a lot of entrenchment, and ultimately stalemate. So what we were experiencing, both from our side and from presumably the contractor side as well, was essentially that the dynamic of the contract administration had been lost, and the project, and that's actually the important thing amongst all of this, the project had actually lost momentum. So how did this happen? Well, essentially what we were seeing was that the parties were avoiding making DAB appointments. So somewhere in the contract they'd actually agreed to have a DAB, but they hadn't got round to, or didn't want to, or didn't know how to actually make the appointment. When they did make the appointment, they tended, for whatever reason, to find people who had actually very little availability. And that was compounded in terms of a lack of availability once it became 3 members that needed to coordinate their diaries. Partly because of cost and partly because of that problem, the standing boards were avoiding site visits. That's partly due to the location of the project relative to where the project's teams were. So there's various reasons for that. Then the parties were investing, in the literal sense of the word, into taking things to the 20.4 decision, very sophisticated claims, all the things that we've been discussing on opposing experts, on counsel, and so on. The whole thing was essentially becoming much more like an arbitration. So when the parties eventually got to in front of their DAB, the DAB was behaving like they were arbitrators, and it was an arbitration. So in terms of the effort, the costs, the timetable, the behavior of the parties and the decision makers, it was essentially looking more and more like arbitration. So what was happening was, yes, they had dispute boards, but what they were trying to do was move out the decisions, push them out almost to a point where it was going to become finality is what they wanted, simply because they'd invested so much money and so much time trying to get to that decision-making process and ultimately a decision. So from this, I think one of the lessons would be is to really understand what the DAB can and should be doing. So on one side, we've got what in the FIDIC contract would be the 20.4 decision-making process, essentially akin to adjudication, but on this international format. These decisions tend to be made quite late in the game. They tend to be quite paper-orientated because the events are long past, and it tends to be a very adversarial process. To go beyond that, you're essentially looking then at arbitration, and ultimately, in some cases, the only real difference to arbitration is finality. On the other side, and this is something that we came across on absolutely no occasion, was under the FIDIC contract, you could ask under 20.2 jointly for the dispute board to give you an opinion. Now, if this had been used, it could have been used early. It could have been much more a people-orientated thing, so people were getting involved and really working together. And it probably, I think, would have been a much more inquisitorial type of arrangement where the parties would have worked with the dispute board in a much more collaborative sort of way to essentially get to a sensible procedure, a sensible document, complexity, and so on, so that they could actually get to that opinion in real time, or as near as practically possible. To go beyond that, in terms of getting an interactive real-time decision or support, or in the 20.2 case, the opinion, the only way to go beyond that would really to go into mediation. And the only real advantage of going to mediation would have been that you could have had separate meetings with the parties. So two very, very contrasting facilities essentially through the DAB, but what we were seeing certainly in the project I'm speaking about today was we were only seeing this 20.4 decision process being used. So in terms of how to make the DAB work, I think the answer to some extent is in the title. You get the DAB to work. So the first thing you need, I think, is the standing board. Now, for a long time in the FIDIC contracts, it was only really the Red Book that had the standing board. On some of these projects, certainly this project I'm thinking about, there was enormous outdoor works being done where some of it was employer designed, so Red Book, some of it was Yellow Book, contractor designed, but the reality was that the standing board was really necessary under both contracts. At the time, that wasn't really what had been envisaged in the FIDIC contracts. That's now been updated. So the standing board. I think then the courage to make the appointments from the outset and to actually genuinely carry them through so that the standing board can actually stand. To really check genuinely that the availability is actually there in terms of the availability between the board members. Do they have time booked aside to be able to work together as the DAB? And do they have real ability and availability to come to site and to be involved in whatever unfolds? So I think in some cases then that means that much as the parties want the absolute A-grade people, sometimes the more local alternatives or the less experienced practitioners may actually be helpful simply because they are likely possibly to have more availability. The other thing that would have helped enormously in the situation in South Africa, I think, is awareness that this 20.2 opinion procedure actually exists and the willingness to actually engage with it and to use it actively and frequently. And there shouldn't really be a problem with doing that, because if you've chosen a DAB that has the right skills and the right experience, and they are your choice of people to be your DAB, then you should actually be able to trust their opinion. So the logic is then, if you can trust their opinion and you value it, why don't you ask for it? So that comes then to giving the DAB the mandate, because they can only act essentially under the authority that's given to them by the parties. But not only the mandate, give the DAB the incentive or the encouragement to actually focus the process and focus the submissions that are going to be exchanged and focus what they need to see. I mean, they should be very experienced people who are very familiar with that type of work on these type of submissions. They should be able to help you enormously in actually cutting the costs and making things really get to the driving points as quickly as possible. Above all, you need to keep the communications open between the members of the DAB, but also between the DAB and the parties, and keep them open at all levels, because some of these decisions and processes, particularly on these very large projects, are almost at board level or CEO level and very senior government figures. So these communications at all sorts of levels are enormously important to keep everything moving. And keeping things moving is ultimately one of the reasons that the DAB is there to start with. And then certainly in some jurisdictions, and primarily international jurisdictions, it's very important, I think, to have a genuine without prejudice route open as well. There are some jurisdictions that don't really understand without prejudice, And there is a tendency, I think, certainly from UK-based people sometimes, to assume that there is a without prejudice route everywhere in any event. And that's, in my understanding as a non-lawyer, is certainly not the case. So it's all about communications and getting your DAB to really do their job. You sign them up, you're paying for them, use them. Thank you.